afternoon, it's me Anubhav Packrell and I'm from Home Institute, which is in Sydney, and my student number is EMV21770, and today I'm going to discuss on a case named Road Safety Authority vs DEDERER, and I'm representing my team, means the team lead. I'm the team leader, and I'm going to defend this case. Okay, actually what happened in this case is like the guy named Philip DEDERER. He was aged 14 and he was dragged from the four-star Tunkery Bridge from the height of 9 meters and connected straight in the water of Wollumba waterway. When he fell down from the four-star Tunkery, he was dropped on a sandbar and he was suffered from cataclysmic personal injury, which was a bit a serious injury. In this activity, there was defender, plaintiff, but what happened is the essential judge, Donford, found that litigant, the general population specialist, was in charge of the scaffold. He has carelessness in neglecting the erect sign, cautioning of the variable level of the water underneath the extension, and the nearness of the sandbar. In the appealing party, likewise, had been careless in neglecting the supplement, means the flat fence railings to the connect with the four-star Tunkery Bridge near the Wollumba waterway. Should not have the vertical railing, and in neglecting the supplements to the level of the water, and should be placed with the handrail with a triangular molded one. The essential judge likewise found that the appealing party's carelessness was the reason for the misresponse. So, my next...
Hi, it's me Anis Subedi and my student ID is EMV21301, and today I'm gonna explain fact of the case, and I'm gonna start now. Plaintiff dived from the four-star Tunkery Bridge from the height of 9 meters into the river of Wollumba, doing negligence to the warning sign on a bridge. Although there was a sign, due to minimal water level, he was struck on a sandbar and suffered from personal injury. As he stated that he knew that the depth of the water dropped suddenly at the edge of the sandbar and the water in the channel was very deep. He also accepted that the depth of the water in the channel was hard to judge due to the flow of the water going under the bridge. As long as the RTA stated that they are aware of people frequently jumping off the bridge, as they replaced exciting pictorial sign of the no diving, but this had virtually no effect and there was no any other accident happened before. Beyond the restriction signage and horizontal bar, other people used to dive, but this the only case of being injured. Road Traffic Authority is in charge of maintenance of the bridge, and in addition also exercise reasonable care and safety regarding the risks on a bridge. Road Traffic Authority fails to keep sign of various water level and presence of sandbar below the bridge. Thank you.
Hi, it's me Raju Adhikari with the student number of EMB21282. I am going to explain argument from plaintiff and argument of defender. Argument from plaintiff. There was no clear sign in the bridge which makes people aware of accident. There was no safeguard to restrict the people from climbing platform. There is not the warning sign in the water level of river. Not appropriate sign to clarify the presence of sandbar. Road Traffic Authority fails to replace horizontal fence railing to vertical railing and to replace flat top of handrail into triangular shape one. Argument of defender are: there is clear sign of warning on the approach of the bridge. The horizontal bar are in the place to restrict to enter rather than to climb to the platform. All the reasonable care has been maintained by RTA to stop diving into water from bridge. These are the arguments from plaintiff and defender. Thank you.
Hey guys, it's Pradeep, student ID EMB 21297, and today I'm going to explain about the judgment of the court on the case of the RTA versus the DEDERER. So on the case, the plaintiff has got injured and he claimed on the Supreme Court for the recovery of his personal injury, while though the primary judge on the Supreme Court, they found the RTA to be the guilty, not to put the symbol for the various water level and the sign for the sandbar below the river. While on the other hand, the High Court of Australia, they found RTA is not liable for every injury held to the person because of their personal negligence. RTA haven't breached any of the duty on the case, because RTA doesn't have the obligation toward the careless user of the road in comparison to the careful one. So that's all about the judgment of the court, and my next friend is going to explain about the conclusion of the case. Thank you so much.
Hi, it's me Divas Adhikari with the student number of EMP21298, and I'm just gonna explain the conclusion of the case of RTA versus DEDERER as a defender. The majority of the Court of Appeal was held that the RTA is reliance no diving sign was signed in all the requirement of the case and insufficient and in unreasonable response to the risk of the injury. The important and essential point is that the RTA did not owe a more stringent obligation towards the careless users and the careful one. In every respect, the decision on the case of DEDERER represents an acceptance of a far more qualified view of negligence law has been evident in the past. This case brings restrictive changes to the common law into stark relief. The emphasis on the obvious risk and personal responsibility is necessitated by the High Court at attempt to limit liability through a consideration of DEDERER's conduct. The question of a scope of duty at a breach of inquiry rather than on the question of contributory negligence. So, RTA is not liable and doesn't hold any of the obligation towards plaintiff for the damages caused by his misconduct and the negligence of diving from the breach. Hence, RTA's duty of care was owed to all the users of the bridge, whether or not to take ordinary care for their own safety. Thank you.